some other news now. And the 4 police officers accused of killing Mthokozisi Ntumba in March last year have been formally acquitted of the murder charges against them. You may remember at one point there was CCTV footage of Ntumba being shot by an officer with a rubber bullet at point-blank range. This all happened during protests by students at Wits University last year. There was huge outrage at the time as Ntumba was killed literally leaving a doctor's office. Well, William Booth is an attorney, director of William Booth Criminal Attorneys. William, good afternoon to you. It seems incredible to us to see footage like this and then to see officers being acquitted. This was a 174 application. How does the law work in a case like this?
Well, Section 174 is in terms of the Criminal Procedure Act. So that is legislation that governs criminal cases. And at the end of the state's case, in other words, once the state prosecutor has presented all of his testimony, then the accused are entitled to consider whether they should apply for a discharge in terms of this particular section. Now, obviously, in some instances, it may be granted, in other instances, not. But the legal principle is fairly simple, and that is, at the end of the state's case, whether there is sufficient, reliable, credible evidence upon which a reasonable person may convict the accused, either some or all of the accused on all or some of the charges. So that's a discretion that the magistrate or judge has in a criminal trial. So it's all about what was the evidence like, what was the manner in which the witnesses were cross-examined. Is the evidence credible? Were there serious material contradictions? So if the court says, well, they're not granting that discharge, then the accused can either not testify, it's their right to make that decision, or then testify to give their side of the story. So, from a public perspective, it's often said, well, we'd like to hear what the accused has to say. But from a legal perspective, he doesn't have to go and give evidence if there isn't sufficient evidence upon which he needs to reply.
It seems a major issue, as I understand it, was that the state could not prove the identities. Now, that's obviously a key point. If you're a prosecutor and you can't prove the identities, you're probably in trouble.
Yes, absolutely. But, a case must be properly investigated. You come to this stage of a matter that surely you've got all the evidence there. It's been all the forensic evidence, footage, CCTV footage or camera footage, or whatever evidence there is, whether it's eyewitness evidence as well, that it's all properly put together, presented to the court, so that at least you are presenting evidence upon which an accused person has to reply and not then get his discharge. So, but, having said that, it also does depend on how the witnesses fare in the witness box. So you might have, as a prosecutor, prepared a witness incredibly well, and at the end of the state's case, the witness is being cross-examined to such an extent that lies have emerged and the presiding judicial officer can't rely on that person's evidence. I mean, to give an example of a very well-known case is the State versus Dewani, a High Court matter that everybody knows about, the so-called honeymoon murder, which took place in Cape Town. I believe there's a series out now in the United Kingdom about it. But it's been, talked about a lot. In that case, the evidence of the witnesses, and they were accomplices and, co-perpetrators, their evidence was so poor that the presiding judge found that there's no evidence on which a reasonable person may convict, and acquitted Mr. Dewani also at the end of the state case. So identity is important, particularly if somebody places identity in dispute and says, look, I wasn't there, or it's that, it's not me, it was somebody else. And, that also has to be, there's got to be sufficient evidence to confirm the identity of the perpetrator or co-perpetrator. So, it's crucial in matters that all this preparation is done. But as I say, even if the evidence is presented where you as a prosecutor think you've got a good case, suddenly those witnesses fall apart and testify badly. Because, that does happen in court.
One of the problems with a case like this, and I'm no lawyer, as you know, but I'm sure it's probably a strong decision. If there's an appeal, I imagine it'll stand. But for ordinary people, I mean, I see the video and I see the acquittal. I'm not even a member of this poor man's family, and I feel aggrieved for him. I mean, it must make people question the justice system. You see it on video, and yet I'm sure no one's now going to be found guilty.
Well, yes, of course, but one must also realize that the court can only make a decision on the evidence presented to it. And there's only certain types of evidence that can be presented. For example, generally speaking, hearsay evidence can't be presented. What somebody's told somebody else. Or if the video or the footage has not been properly presented to court, there may have been an issue with authenticity, the correctness, the chain of custody of the evidence. So all of these factors, are taken into account by the presiding judge, and it's not necessarily a case that the justice system or the Justice Department has fallen apart. Look, maybe it has to an extent, but on the other hand, a court must look at all the evidence and consider, is it reliable or credible? Is it admissible? So the public see, well, hang on, there's the evidence. And you might have had evidence handed down, particularly if it's on video or by photographs taken on camera, where it might have been manipulated or distorted or, it's not properly preserved. So all of these are legal aspects. It's the same as when somebody arrives at a crime scene. To trample all over the crime scene could affect the credibility and reliability of evidence that is later gathered, forensic evidence that is later gathered, and it could have a significant effect on a case. So where a member of public says, well, like you're saying, well, they should have been found guilty, the court is faced with a number of issues which it has to consider, and, bearing in mind the Constitution, everybody's presumed to be innocent, the state must prove its case, and, the onus rests on the state to prove its case, not on the accused person. So I think, the problem with all cases in South Africa, Stephen, is the public are not properly informed about what happens in court. And sometimes you see court cases that are televised, and sometimes lawyers are acting in not the correct way in dealing with cases and not even presenting the case in the proper fashion. And, that does happen, but the public sees that and sometimes comes to the wrong conclusion. So I think one needs to, tell the public this is what happens in court. These are the rules that the court has to comply with, and you can only convict if the evidence is sufficient to convict on. Otherwise, the person must be acquitted, even though you think they may be guilty. It's, the test beyond a reasonable doubt. And, if the person is possibly not guilty of the offense, is there a reasonable possibility that his version may be true? If there's doubt in a case, then the accused person, whether we like it or not, has to get the benefit of the doubt. And that's an internationally recognized principle of criminal justice.
William Booth, we have to leave it there. Thank you, the attorney. I do appreciate it.